Someone make it make sense.
Probably a couple.
Good evening, everybody. So, all right, y'all, I refreshed the Idaho Cases of Interest page right before I went to go start the live stream. And guess what? We have another brand new document out of Idaho that I don't know that anyone's even seen it yet because it just was filed at 10:25, but it's 3 hours earlier there. Anyway, this just got posted and it was from today. And so we have news onto where this trial is going to take place and who the new judge is going to be. And this literally just came down. So the plan for this live stream was to cover the order granting the change of venue and the rest of the death penalty documents. We're still going to do all of that, but we are also going to, of course, obviously cover this brand new order and find out where is the trial going to take place and who's this new judge going to be and see if we can learn anything about who this judge is. And so, yeah, very exciting stuff. You're in the right place if you want the literal latest out of LATA. Wow, that's a lot of L's. And going forward, it may not be LATA anymore. Actually, we know it won't be. So first things first. My Squirrely crystal ball has been so on point that I made a special bumper just for the crystal ball, and it's highly relevant to this little clip I'm going to play here in a second. So first, let's roll that new bumper. Some of you guys may have seen it last night, but let's go ahead and take a look. Okay, so now for the little clip that I had already prepared, and this is from the live stream on Sunday. And just to refresh everyone's memory, we did the live stream on Sunday, finishing out the hearing with the motion to change the venue, and we covered a lot of the motions to strike the death penalty. And on this live stream, a couple funny things happened, and this is just a short little clip, and this is why I ended up making that crystal ball bumper. So let's take a look at that here. All right, so from Sunday, September 8th.
Don't answer all the questions at once, Your Honor. Answer the first one first.
Ooh.
And then think about where it's most reasonable to have the trial.
Wow. Dude, that's Ann Taylor. Dude, you guys, that was so smart. Let me back that up. So she waited for him to kind of like say, I agree with you, right? So he's listening and he's like, it's like now it's like more like two-way conversation. And she knows that he's listening and now she's giving him advice. Oh man, brilliant. Let's back that up. Wow.
And it's important to make math. We're 9 months from trial and we need to have the venue issue settled. We need to be able to have our subpoenas out. We need to have our experts plan. We need to have time set aside. I've got my time set aside, but we need to have our experts be able to get tickets and reservations for hotels. Don't answer all the questions at once, Your Honor. Answer the first one first.
And she's
and
right.
Think about where it's.
That's what their expert said. The expert said the first question is, and that's why that was really smart because she asked him a question and he gave that answer, and it was like a non-leading question and he gave that answer, and she's using his answer, which was brilliant because what he said was, it's not about where to change venue. It's if it should change venue first. That's the first question is if it should change venue. Then the second question is where. So she's quoting that from the expert. Smart. Yeah. So why did I include that? I included that clip because when we get to this order, we're going to see that that's exactly what Judge did. Literally. He literally did that. He followed that exact advice and he made a decision on if it should change venue, and that's it. Okay. So, but we'll get to that in just a sec.
Most reasonable to have the trial. Think about the differences in the communities. But answer the first question first. We can't have this trial here.
It's like, this isn't the hugest decision, blah, blah, blah. Answer the first thing, baby steps, right? She's, it's smart.
There's no way Mr. Kohberger can get a fair and impartial jury.
In the wake of the slew of documents that have come out that we're still making our way through regarding the death penalty. This makes me wonder if there's going to be an answer kind of soon, because they've now got to start dealing with all of this, and they're going to have to set a hearing. It makes me wonder, because tomorrow's Monday, if there could be an answer. I don't know. I mean, I can't predict the future, obviously, but
Or can I?
it would feel like maybe tomorrow, like it would feel like that might have been enough time. Because my squirrely crystal ball has been on point tonight, like on another level. So I may as well go out on a limb and say, I wonder if we might hear something from Judge tomorrow, with a decision about the motion to change venue.
So sure enough, this live stream, this clip was from Sunday, right? Sure enough, on Monday, we got a decision. And I was going to have this live stream, the one we're doing right now, I was going to have this earlier, but I had a feeling, I was like, I feel like there's going to be something else coming out. And so sure enough, literally right before, like I said, right before I started the live stream, what do we have? We have the order with transferring the venue and appointing a new judge. So crazy. Okay, so first, let me pull this up. All right, so we're going to go through these one by one. So first of all right, this came out on Monday, as some of us predicted. Shout out to the Squirrely crystal ball. And this is the order granting the defendant's motion to change venue. All righty. So we're not going to read this introduction because we know all that, hopefully. So, okay. At the hearing, defendant presented expert testimony from James Todd Murphy, Dr. Amani L. Alali, Dr. Brian Edelman, and Dr. Veronica Deere. The state did not call any witnesses. And you know what's so interesting is I pointed that out, and I'm sure I wasn't the only one, but I was like, when they were getting ready for this hearing and they were like, yeah, we're not calling any witnesses, I was like, pardon you? Because that's a bold statement when you've got the defense pulling out all these witnesses, expert witnesses, and all these documents and all the exhibits, and the state didn't call any witnesses. And I was like, okay. So it looks like that also left an impression on Judge. The court has spent many months carefully considering the legal and logistical concerns with a trial of this length and magnitude, carefully reading each submission, listening to each expert, and evaluating each party's position. Based upon the totality of the factors, defendant's motion for a change of venue is granted. Again, we're not going to read all this background because we hopefully already know this. I do appreciate him saying this, though. Okay. Throughout the course of the investigation, the Moscow Police Department, in partnership with the University of Idaho, the Latah County Prosecutor's Office, and the Idaho State Police held press briefings to answer questions and reassure the public. Appropriately, the information released was limited to protect the integrity of the ongoing investigation. So I really like what he said here, and here's why. Because we know that there had been some back and forth between Dr. Edelman and Prosecutor Santa. Shout out to, Spicy Santa. That was when, oops, sorry, that's not him. There he is. That was when things got real spicy between them two, when he was Dr. Edelman was kind of trying to insinuate that Bill Thompson himself had poisoned the jury pool by holding these press conferences. And I was actually pushing back and saying, well, I thought it was the right call because otherwise people were just going to speculate. He was saying, here, we're going to have a gag order, as it were, right? And a non-dissemination order. And I'm going to make sure that we want people to have the accurate information and public record, right? Court filings. So he's like, everyone should just read the PCA. And I was like, that's the way to do it. So it looks like Judge also has that same sentiment where he's saying that, yes, they were holding the press briefings, but it was appropriate because the information was limited. So it protected the integrity of the investigation, but it provided people with information. So, all right. He was arrested. Okay. Here we go. Because of the extensive media coverage from the outside of the homicides, non-dissemination order was also quickly put into place by stipulation of the parties on January 3rd. They were talking about cameras. Okay. Despite efforts by the parties and the court to protect the jury pool from being inundated with information that is potentially prejudicial and false, extensive media coverage by mainstream media sources such as newspapers, radio stations, and television news outlets has continued throughout the state and nationally. Additionally, and perhaps more challenging, is the ongoing spread of prejudicial misinformation, rumors, and patently false theories of the case on social media outlets such as Facebook, podcasts, and blogs. And unfortunately, you know, there's nothing you can do to stop that because people are going to be stupid, unfortunately. You know, you can't, you know, that's freedom of speech, right? People are going to do that. There have also been numerous television shows and documentaries, in quotes there, produced about the homicides, and at least one book has already been published. The parties agree the case has generated extensive coverage by the media, internet sleuths, and others trying to capitalize on the tragedy, but disagree on how the court should attempt to remedy the issue to ensure Kohberger is tried by a fair and impartial jury. In sum, Kohberger argues the venue must be changed from Latah County to a location with a larger population that is geographically distant from where the homicides occurred. And I think that's an important distinction that he's making here, because we know that part of the issue is like the traveling, right? That it could be difficult or inconvenient or, you know, unfair for everybody, the victims' families, but not just, I mean, also the attorney, for everybody, right? The attorneys, whatever, to have to drive a distance. But he's making sure to make this distinction that the geographic distance is actually part of what's necessary to be far enough away from Latah County. And I did point this out in the last live stream that with Chad Daybell and Lori Vallow, they were both granted a change of venue from Fremont to Ada County. And I did look up the time it would take to drive between Fremont County and Ada. And I also looked up the time it would take to drive from Latah to Ada County, because I figured, well, if it was granted there, let's see how far apart those are. So Fremont to Ada County is something like 5.5 hours. And then Latah to Ada is like 20 minutes longer. So I mean, at that point, they're basically the same. So again, that to me was an indication of like, well, then I can't imagine this wouldn't be granted, right? In other words, that is allowable to have that much of a distance for the drive, right? The state asserts that a larger juror pool, extensive juror questionnaires, and voir dire are sufficient remedies that will result in a fair and impartial jury in Latah County. In addition to the issue of juror prejudice resulting from extensive coverage of the homicides and Kohberger by the media and others, and the smaller population of Latah County, the defense also asserts that the trial should be moved outside of Latah County, quote, for the convenience of the parties and witnesses and in the interest of justice, end quote. The state disagrees that moving the trial would be in the interest of justice or convenient to the parties and witnesses. Okay. The evidence. So we've seen the evidence. I don't know that it's necessary to read all of this. I'm just going to highlight a couple things because we watched the hearing. We also read the whole memorandum. So of the mainstream media coverage in Idaho, 36% of that has been within Latah County. And again, he's referencing the memorandum. Again, we covered all of that. All of this taken together means that the probability of a Latah County resident being exposed to media coverage of the case is much higher than the probability of an Ada County resident being exposed to media coverage of the case. Now he's going to summarize Dr. Aleli's findings. And this has to do with the sentiment of the public and the community. Again, it's a close-knit community. Community members feel a sense of loyalty to community views and fellow community members. So yeah, we know all that. And again, this is the other thing where I think the geographical distance matters, right? From what Judge has said, the Latah County residents had a much more emotional experience surrounding the homicides and are much more invested in the case. They felt a greater sense of fear compared to the other nearby counties. And then Dr. Edelman, key findings from the survey show that the case recognition is high throughout Idaho. 98% of survey respondents in Latah County recognize the case. 93% in Ada recognize the case, and then he's comparing it to other ones. In Latah County, of the 98% of respondents that recognize the case, 67% reported they believe he's guilty. In Ada County, 68% of respondents who recognize the case believe he's guilty. The percentage of respondents who reported that Kohberger would have a difficult time convincing them he is not guilty was actually higher in all the other counties surveyed. So these numbers are kind of interesting, right? So again, if you just take a look at like 67% in Latah believe he's guilty, 68% who recognize the case believe he's guilty in Ada, right? So, and this was one of the points that the prosecutors were arguing because they were saying like it's actually lower in Latah for this particular statistic, right? But where I'm sure he's going to get to is the point about the number of people, right? So, and that's probably going to come, you're right. So the population size. So, finally, Dr. Edelman considered the population sizes of the counties surveyed, with Ada County having, well, almost 500,000 residents compared to these other ones. Latah County has only 32,515 residents. Based on all the information obtained from the surveys, Dr. Edelman opined that case recognition and presumption of guilt is and will continue to be high throughout Idaho, given the extensive media coverage the case has generated. In his opinion, population size matters. Right. That's right. Like I was saying, for example, if roughly 50% of Latah residents presume Kohberger is guilty, that leaves approximately 15,000 Latah County residents who do not hold this presumption. So that's what it comes down to. It's because there's so few people in Latah County, it just still leaves too few people to pull from a jury pool. So of those, not all are eligible to serve as a juror, right? In contrast, if 50% of Ada County residents presume Kohberger is guilty, that still leaves over 200,000 residents who do not hold such a presumption. Thus, Ada County has a much larger pool of non-biased potential jurors. So talking more about the personal impact. Now we're going on to Dr. Dyer, however you say that last name. Just talking about the volume of the coverage. I think we're all well aware of that. So the standard here, I think we're aware of that as well. Okay, analysis. Here we go. So, prejudice. In deciding a motion for a change of venue, the court determines whether, in the totality of the circumstances, juror exposure to pretrial publicity will result in a trial that is not fundamentally fair. The critical inquiry is whether the nature of their exposure to pretrial publicity caused the prospective juror to form an opinion about the defendant's guilt, and as a result, they are unable to serve as an unbiased juror. In determining whether a criminal defendant actually received a fair trial, the Idaho Supreme Court considers the following factors. 1, the existence of affidavits indicating prejudice or an absence of prejudice in the community where the trial took place. And 2, the testimony of the jurors at jury selection regarding whether they had formed an opinion based upon adverse pretrial publicity. 3, whether the defendant challenged for cause any of the jurors finally selected. 4, the nature and content of the pretrial publicity. And 5, the amount of time elapsed between the pretrial publicity and the trial. Some of these factors can only be evaluated during or after jury selection, while others can be evaluated by the trial court in deciding an earlier motion change venue. Actual prejudice. In evaluating actual prejudice, the relevant question is not whether the community remembered the case, but whether the jurors at trial had such fixed opinions that they would not judge impartially the guilt of the defendant. Stated differently, courts must evaluate whether, in the totality of the existing circumstances, juror exposure to pretrial publicity resulted in a trial that was not fundamentally fair. The defendant bears the burden, right? So this is like in the trial, in the motions, like we've already heard this already happened, right? The defendant bears the burden of proving the prejudice, and that's why they had to bring in the people, proving the prejudice or showing a reasonable likelihood that there was prejudice. In reviewing case law, a finding of actual juror precedence, rests on an examination of the jury selection process. This includes evaluating how jurors answered screening questionnaires, the testimony during voir dire of the veneer, or if you're in South Carolina, you might say veneery as a whole, and the jurors eventually seated, and any jurors seated despite a for cause challenge by the defense. These factors are considered along with evaluating the pretrial publicity itself and the timing of the publicity. Here, the defense argues that the survey work of Dr. Edelman establishes actual prejudice within Latah County. However, actual prejudice cannot be evaluated at this juncture based on a survey on some 400 Latah County residents who are anonymous, because they did not answer the questions in court, right? And they were not subject to questioning by the state. Without attempting to seat a jury, there's no real evidence, such as juror screening questionnaires and testimony during voir dire, for the court to evaluate actual prejudice. Now that takes us to presumed prejudice. All right. Adverse pretrial publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed. However, a presumption of prejudice attends only the extreme case, and juror exposure to news accounts of the crime alone does not presumptively deprive the defendant of due process. So that's really crucial. There's a lot of things here, okay? Right? So the first part is this. If there's so much adverse pretrial publicity, even if a juror comes in and says, yeah, I can be impartial, one has to evaluate whether or not that's accurate, right? And we've heard from these experts about how people overestimate their ability to be fair and unbiased, right? But then the next part is that the presumption of prejudice is only is for the most extreme of circumstances, right? And then also that just exposure to news accounts of the crime does not presumptively deprive the defendant of due process, right? And what they're going to, I'm sure, get into is it has to be adverse, right? So unlike with actual prejudice, a finding of presumed prejudice means that the court need not consider juror screening questionnaires or testimony during voir dire before declaring a jury verdict void, or in this case, declaring a change of venue appropriate based on prejudice. It is the defendant's burden to establish a reasonable likelihood prejudicial news coverage prevented a fair trial in violation of the Sixth Amendment. This is not an unreasonably high hurdle for a defendant to clear, right? So even though the defendant has the burden in this case to prove it, it's a low hurdle, relatively speaking, right? To clear. Why? Because we want to protect the defendant's Sixth Amendment rights. In cases where juror prejudice has been presumed, the following factors have been examined: size and characteristics of the community in which the crime occurred, whether news stories contained a confession or other blatantly prejudicial information, the lapse of time between prejudicial news coverage and the trial, and what the jury actually found as far as guilt was concerned. In Idaho, courts consider 1, the existence of affidavits indicating prejudice or an absence of prejudice in the community where the trial took place, such as we saw from the experts, and 2, the nature and content of the pretrial publicity, 3, the amount of time, and actually he already cited all this, but yeah, amount of time elapsed. Okay, so again, we're familiar with that. First, as to the size and characteristics of the community, Latah County is a relatively small community with a population of approximately 41,000, but less than 25,000 who are eligible to serve on a jury. The state argues that this is enough to impanel 18 impartial individuals. The defense argues that the small, tight-knit community makes it impossible to find impartial individuals because of the extensive publicity Latah County residents have been exposed to, emotional experience, blah, blah. We've already heard all that. As Mr. Murphy testified, 36% of all mainstream news coverage of this case throughout Idaho has been in Latah County. Okay, again, he's quoting more from the experts. We know all this, so I'm going to keep going. And this one I think is important. Potential jurors in Ada County, for example, this is where the geographic distance matters, right? Potential jurors in Ada County, for example, did not experience the same level of fear caused by the homicides as Latah County residents. Similarly, it's far more likely for jurors in Latah County to know someone involved in the investigation of the case or otherwise related to the case, right? Additionally, smaller community makes it more difficult to keep jurors private. Okay, more about the media coverage. Okay. Finally, while this court does not have affidavits demonstrating prejudice in Latah County, the court must first consider the results of the survey Dr. Edelman prepared. Again, while the presumption of guilt was similar across the county survey, the number is more impactful in Latah County given the smaller population. That's what it really boils down to. Some 67% of Latah County survey respondents reported believing Kohberger is guilty, with 51% of those indicating it would be hard for Kohberger to convince them of his innocence. Burden shifting. While a similar percentage answered these questions the same in Ada County, the impact of these numbers when considering population size are drastically different. Latah County has approximately 24,000 residents who are eligible for jury service. If 50% of those are disqualified for having fixed opinions as to Kohberger's guilt, only 12,000 individuals remain. This is before any have been excused for hardships such as illness, breastfeeding, loss of wages for a 3-month-long trial, sole child care provider for young children, etc. Thus, when considering the prejudice in Latah County demonstrated in Dr. Edelman's survey and the population size of Latah County together, the court is concerned that if the venue is not changed now, it will be asked to reconsider its decision during jury selection, which, if granted at that juncture, would very likely result in the trial being delayed many months. That's a good point to make, right? Because we all know that everyone, there's been, most people are of the opinion that, this trial is taking so long and why is it not happening? And, it's scheduled for next summer, 2025. So he's making the point that if this wasn't done now and it ended up being done once they've started, the jury selection process, they would have to push it out even further, right? Considering the undisputed evidence presented by the defense, again, undisputed because the state didn't call any witnesses, the extreme nature of the news coverage in this case and the smaller population in Latah County, the defense has met the rather low standard of demonstrating a reasonable likelihood that prejudicial news coverage will compromise a fair trial in Latah County. Thus, the court will grant Kohberger's motion to change venue for. And I have to say, I wonder if the prosecution knew that this was going to happen. Because really, in a way, it's like they didn't really try. You know what I mean? Like, it makes one wonder that even if they had brought experts in, would it even have made a difference? Because again, the reasonable likelihood hurdle is so low, and the importance of maintaining a defendant's Sixth Amendment right to a fair trial is so important that if it's leaning one way or the other, it's going to go to changing the venue, right? I would imagine. So, but again, the fact that they didn't even bring in any experts, I just have to wonder if, again, even if you just look at the precedent of, like, again, the example I gave before, Lori Vallow and Chad Daybell, and I'm sure they're not the only ones, but just in recent memory. And also, again, being the same amount of distance from where the venue was initially to where it was changed, they might have just been like, well, this is just going to happen anyway. I mean, I don't know. Like they didn't really, in my opinion, seem to really try to keep, you know what I mean? Like, again, even one expert would have maybe made it seem like they really tried a little bit harder to keep it there. But I think that maybe, again, they just thought this is going to happen anyway. So, okay, convenience and interest of justice. Even without finding a presumed prejudice, venue in this case must be changed for the convenience of parties and witnesses and in the interest of justice. While this issue was summarily addressed by the parties, the court considered the logistics while the motion for change of venue was pending. Now, this is where we learned some new information that we actually didn't have from the hearing. So this is from the judge, right? This was not in in anything that we've heard before. This is new information. While Latah County court staff and court security are ready and willing to facilitate this trial to the best of their ability, there are serious issues that cannot be resolved no matter how much planning and preparation is done. First, and perhaps most important, is the issue of safety and security for the families. The Latah County Sheriff's Office, which is currently fully staffed, simply lacks a number of officers to provide security for the trial while performing their day-to-day duties, blah, blah, blah. So just basically just not enough law enforcement, essentially. But let's go on to the next part, because that's even more, I think, important. Similarly, Latah County does not have enough clerks to efficiently manage the jury selection process. It is anticipated that general qualification questions will need to be sent out to some 6,000 individuals. The court clerks will be tasked with then entering juror information from those 6,000 individuals into an electronic system. This task alone will require several clerks and will take time. Latah County has only one court clerk familiar with the process. Incredible. And she has several other day-to-day responsibilities outside her role as jury commissioner. Thus, to accomplish this task, Latah County would have to bring in clerks from other counties to help, along with extra computer equipment for those clerks to perform their work. After the initial process, the court would summons in some 1,800 individuals to fill out extensive juror questionnaires. Again, this process would require both court clerks and court security to take attendance, manage and move the individuals where they need to go to fill out questionnaires in privacy, scan questionnaires, and quickly get the questionnaires to the court and counsel. Again, while Latah County court staff are willing to do what needs to be done, the reality is they just don't have enough people, basically. Further, the Latah County courthouse itself poses significant issues for a trial of this length and magnitude. The courthouse lacks space needed by both the state and the defense. While the state has a dedicated space within the courthouse, the state would be faced with the challenge of escorting sensitive witnesses. When the defense, meanwhile, does not have a dedicated space, blah, blah, blah. They've got some areas, but they're not soundproof. Further, the jury room itself is problematic in terms of its sizing. Fitting 12 to 13 jurors in the jury room for a routine trial is crowded. Fitting 18 jurors in the jury room for 3 months would be uncomfortable at best. Additionally, the door between the jury room and the courtroom is not soundproof. I mean, it just goes on and on. Like, basically, it would be a disaster, essentially. Further, there's also the issue of continuing day-to-day operations at the Latah County Courthouse. The magistrate judge would continue. Like, basically, everything would have to stop working, and it would all just go, be a disaster anyway. From all these normal court operations will undoubtedly be strained by the resources required for this trial in terms of space and personnel. But again, it sounds like it's impossible anyway. They wouldn't be able to fit them in. They don't have, it's just not possible. I mean, really, the whole thing about the court clerk, only having the one court clerk who can even do the jury questionnaires, like that's really kind of a done deal right there, I would think. While traveling to another county for 3 months is indeed inconvenient for the attorneys, the court, some family members of the victims, and some witnesses, having the trial at the Latah County Courthouse would also be inconvenient. And that would blah, 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 blah. Okay, yeah. All right, conclusion in order. Here we go. So, Kohberger's motion to change venue is granted pursuant to Idaho criminal rule, blah, blah. So here is where I, like, at the beginning of the live stream, I played that clip from Ann Taylor where she's like, just the first things first, just first step, Decide if it needs to be changed, right? Don't decide where, just decide if it needs to be changed. And literally, that's what he does. So orders a transfer of venue without specifying the new place of venue and refers the case to the administrative director of the courts for assignment by the Supreme Court to a proper venue in another judicial district and assignment of a specific judge to preside in the criminal proceeding. I have to tell you guys, when I saw this, I was almost in tears because I was like, wait, no more judge. And, I understand he could have requested to stay with it. My thought on this personally is that he left it up to the court and the court could have appointed him anyway. Like the director of the courts could have still assigned him. And that way, if that happened, it wouldn't have been like he was requesting to stay on, which I think would have been a smart move because of the fact that there's been some, as we heard, the aftermath, there's some problems with the victims' families not liking Judge or thinking he's being siding with the defense or something, which, I don't agree with, but anyway. But that way, if he didn't ask to stay on, but instead was appointed yet again, that would have been like, well, it wasn't up to him, right? And anyway, so I don't know if that was sort of the idea behind it, but here's the thing. This is the document that just came out literally right before this live stream. And we have news, guys. Here we go. You guys ready? We're going to learn where is it going to be and who's the new judge. All right. Order. Granting defendant's motion to change venue is entered. All right. Here we go. Therefore, after due consideration and good cause appearing, it is so ordered that venue for all further proceedings in this case are transferred from Latah to Ada. We're headed to Ada County. It is further ordered that District Judge Stephen Hippler shall be assigned to this case and may not be disqualified without cause pursuant to Idaho criminal rule. It is further ordered that the defendant shall be transferred forthwith to the custody of the Ada County Sheriff. Wild, right? Following in the footsteps of Chad and Lori. It is further ordered that the district court clerk for Latah shall file and serve this order upon the parties or their counsel and take any action necessary to transfer venue of this case to Ada County. And there we are. We're now in Ada County, and we have a new judge. So, Stephen Hippler. So that's going to be our next cause of action. Our next plan is let's see if we can find out anything about him. I'm sure we can. So that doesn't have a whole lot of information. Okay. Here we go. Look at that. Look at that. Fancy. Okay. So that's him. I'm going to miss Judge, you guys. I'm really going to miss him. Gosh darn it. In 2013, I'm sure this guy's great, but I loved, he's got to live up to Judge's, sense of humor and sense of childlike wonder. And also, I really thought he was very fair and he gave due and thorough consideration. Anyway, that's just my personal opinion. All right. So this is the new one. So he was appointed district judge for the 4th Judicial District Court. Graduated from the Order of the Wife University of Utah College. In addition to his civil and felony criminal calendar, Judge Hippler presides over the Ada County Mental Health Court Program. Okay. Immediately prior to taking the bench, Judge Hippler was a partner at Gibbons Pursley LLP. Before that, he was a partner at Hall, Farley, Obrecht, and Blanton. In private practice, Judge Hippler primarily represented doctors, hospitals, and other medical providers in med-mal. Wow, interesting. So looks like that's, a fair amount of background there. And if in terms of his being an attorney, right? Med-mal, right? Civil. Well, there he is. I'm so sad about Judge though, really. Okay, but let's move on because we have more documents. But there you go, guys. Ada County and Judge Stephen Hippler is the latest. So, all right, so we're going to pick up where we left off with these motions to strike the death penalty. And also, I'll just note that we covered there was a whole bunch of these, right? The other, whatever it was, 8 of them or something, I think it was 8, we covered in the previous live stream. And the link to that is going to be in this, it actually probably already is in this video's description. And there's timestamps for all those documents in that live stream. So for the other documents, you can look there. And there should also be a link to the playlist as well for the coverage that we've been doing of this case. But now we're going to be taking a look at the remaining documents that we had not gone over yet. So at IT, motion to strike notice of intent to seek death penalty on grounds of failure to present aggravators to neutral fact finder. Okay, the Constitution requires a neutral fact finder to determine where the death penalty may be pursued. The process provided to Mr. Kohberger up to this point has failed to adequately protect him from being arbitrarily selected for the death penalty in violation of the 8th and 14th Amendments, in that no check was placed on the discretion of the prosecutor. The prosecutor has previously told this court, what the state is trying to do is enforce the law that our legislature has put in place that says, in cases such as this, in facts like this, a jury is entitled to decide not only guilt but potential penalty. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion and has no place in this courtroom. And there's a footnote. There it is. However, as the prosecutor knows from his own experience in refusing to pursue the death penalty in State v. Lee, the decision to pursue the death penalty falls entirely and unreservedly to his own personal decision. Interesting. So here it sounds like he's actually talking directly to Bill Thompson, right? And it would seem like this was another case that Bill Thompson was the lead prosecutor on and decided, I guess, not to pursue it there. Yep, there it is. There's the footnote with Spicy Santa. All right, selecting candidates for death. Oh, I hate this. What a horrible thing. In Idaho, the decision to pursue the death penalty is the prosecutor's. Idaho Code, and there it is, provides the penalty for first-degree murder is death or life imprisonment, but it may only be death where the prosecutor files notice of their intent to pursue death. The statute provides the prosecutor may drop their pursuit of the death penalty at any time, and if they do so, death cannot be the outcome of a case. The only limitation on the prosecutor's ability to seek the death penalty then is that it should be a first-degree murder case and that the prosecutor can find one circumstance of the case called a statutory aggravator. Now, for as far as all those statutory aggravators, there's 5 of them in this case, and those we covered all 5 of those in the other live stream. Again, that link will be in the description. We covered each one of those. I'm sure they'll be referenced in these other motions that we're about to read, but for more on the statutory aggravators, you can check it out there. As explained in detail in Professor Cover's book here, due to the broad and vague nature of both what constitutes murder and what constitutes an aggravator, almost every murder is eligible for the death penalty law. Professor Cover and her team analyzed first and second degree murder cases in Idaho filed between June 2002 and the end of 2019. They found that 86 to 90% of all murder convictions were factually first-degree murder cases, and that 93 to 98% of those factually first-degree murder cases were eligible for the death penalty under Idaho's scheme. In fact, the scope of Idaho's death penalty is constitutionally defective in its own right. Wow, that's a statement, which, as will be argued in a separate motion, let me read that again. In fact, the scope of Idaho's death penalty is constitutionally defective in its own right, as will be argued in a separate motion. Thus, there is no jury, quote, entitlement, end quote, to the death penalty. There's only the decision of the prosecutor that sets the defendant upon this path. The consequence of placing no check on the prosecutor's discretion to seek the death penalty is a system in which geography plays the largest role in determining whether the accused will possibly be executed. As Justice Breyer found, geography plays an important role. Okay, right. So there you have it. Some studies indicate that the disparity in charging reflects the decision-making authority, the legal discretion, ultimately the power of the local prosecutor. So I'm citing some case law here. Oh my gosh, I thought that's the Alameda, and I'm like thinking like, Murdoch. Anyway, it's Alameda. As will be shown, the lack of a check on this discretion violates the Constitution. Grand jury requirement of the Fifth Amendment. The Fifth Amendment requires that a grand jury pass upon any case involving the death penalty. That right, as Mr. Kohberger has argued previously, was intended as a shield against government run amok. It was so reversed by the colonists that Madison, we know who wrote this one, that Madison enshrined it in the Fifth Amendment, even as Hamilton argued against it. Despite this, the Supreme Court, the U.S. Supreme Court, in this case of Hurtado versus California, but from 1884, determined that the amendment should not apply to the states through the 14th Amendment. The Supreme Court in Hurtado held that the grand jury requirement was simply a choice made by the writers of the federal Constitution, and certainly not one required by due process, if only because the words due process appear in a separate clause. Why do I feel like we're going to get to the intent of the framers? The court held that the words due process that appear in the Fifth Amendment did not enshrine a particular form of procedure and allowed for the growth of the law. The court compared due process. Oh my God, there it is. We're back to the Magna Carta, guys. Woo, we did it. We did it. Full circle all the way back to the Magna Carta. There it is. Oh my gosh. How did everybody miss this? On LawTube. Okay. So the court, the court compared due process upon the insistence of the defendant to show the words, to the words law of the land in the Magna Carta. The defendant's choice was a poor one, as the court was easily able to show the many ways in which criminal procedures in England had changed since 1215. A good year. There. The court went on to hold that an adversarial preliminary hearing before a magistrate afforded the liberties of the defendant enough protection to qualify as due process. Strikingly, the court in Hurtado does not discuss the foundation and purpose of the grand jury or the circumstances behind the amendment. In a sense, Hurtado was an affirmation of the sentiment against the jury system that was common in the late 19th century. For example, the court also stated in dicta that jury trials were not required in criminal cases by the due process clause. The jury trial was already guaranteed in Article 3 of the Constitution, and the guarantee appears again in the Sixth Amendment. As the Supreme Court would eventually hold, it is clear that due process, as it was understood by those who wrote the Constitution, the framers, required a jury trial in criminal cases. More recently, the Supreme Court has found that all elements, sentencing factors, and any other fact that a jury would need to find at a trial must be found by the grand jury in federal cases under the Fifth Amendment. This holding was in view of the court's recent jurisprudence on the importance of the jury as a fundamental right of every citizen to protect them against governmental abuses of power. In view of the renewed interest in the intention behind the jury requirements contained in the Constitution, this court should do what the court in Hurtado chose not to do. Consider the function of the grand jury, how it came to be specifically required in the Fifth Amendment, or whether it was considered a part of due process when the 14th Amendment was adopted. This court will find that the grand jury could not have been replaced by the preliminary hearing or the probable cause findings of magistrates, because the grand jury's main function was not the determination of probable cause. I knew we were going to get back to this. Because I knew he wasn't going to let us go. Jay Logston. This is his baby. This is the sword that he's going to die on, is this whole thing about probable cause with the grand jury, or if it's beyond a reasonable doubt. I knew we were going to come full circle. When I saw the words Magna Carta, I was like, yeah. Okay, the grand jury's main function was not the determination of probable cause, but rather its ability to exercise discretion as to which cases were worth pursuing, as outlined above. Thus, by doing away with the grand jury, those states that have done so have simply left their citizens at the mercy of the government. Okay. George Edwards, whoever that was, wrote, there are many cases of a trifling nature which are returned by the committing magistrates when brought before the grand jury, What? Hold on. Let me read this again. There are many cases of a trifling nature which are returned by the committing magistrates, and when brought before the grand jury, the indictments are ignored. Okay, got it. In counties where the volume, it's interesting because that kind of flies in the face of that old saying, that a grand jury would indict a ham sandwich. So I don't know. I'm not going to read all this. This is long. Okay. The truths now appear stronger than ever as the result of allowing career prosecutors allowing career prosecutors to determine who shall be accused. So, all right, okay. Interesting. I think in a way, he's kind of trying to liken this to the whole thing that the Constitution was trying to prevent, which is the government like overreaching to people, right? And I think maybe kind of where he's going with this is like where we were, separated from England and didn't want, the government to be able to do this and that and the other thing, Constitution and all that. That now it's almost in a way the same because now it's just the powers in career prosecutors. I think that's kind of maybe where he's going with this. The people in the courts grow cognizant of the fact that prosecutors with unhampered discretion tend to overcharge cases to coerce pleas, and that the concept of prosecutorial discretion has become substantially eroded by the self-selecting pool of modern prosecutors who file the most serious charge they can in every case presented to them. Many of these issues are also discussed by Justice Harlan in his dissent in Hurtado. Okay, not going to read all that. Considering the intentions of those that wrote the Constitution, the framers, and the importance they placed on the grand jury, Hurtado must be overruled and the right to... Well, I mean, you're going to have to take that up with the Supreme Court, though. You know what I mean? As far as that goes. But yeah. And the right to grand jury, an infamous and capital offense guaranteed by the Fifth Amendment to the United States Constitution, to be applied to the states. Okay. Grand jury requirement of the Eighth Amendment. All right. Let's see what's going on here. Okay. Arbitrary and capricious. The Eighth Amendment to the Constitution of the United States prohibits the imposition of cruel and unusual punishment. Well, yeah. In 1972, the United States Supreme Court determined that the death penalty had become cruel and unusual through its disuse. On one hand, the court was deeply disturbed by the prospect that the death penalty's apparent arbitrary application may be an actuality discriminatory application. On the other hand, members of the court were concerned about ensuring that the death penalty be used in cases that merited its use. So different issues there. Death is truly an awesome punishment. I think hopefully you guys know awesome as in terrible, right? The calculated killing of a human being by the state involves by its very nature a denial of the executed person's humanity. The contrast with the plight of a person punished by imprisonment is evident. An individual in prison does not lose the right to have rights. Ooh, that's interesting. An individual in prison does not lose the right to have rights. A prisoner retains, for example, the constitutional right to the free exercise of religion, to be free of cruel and unusual punishments, and to treatment as a person for purposes of due process of law and the equal protection of the laws. Yep. A prisoner remains a member of the human family. Moreover, he retains the right to access to the courts. His punishment is not irrevocable. Apart from the common charge grounded upon the recognition of human fallibility and the punishment of death must inevitably be inflicted upon innocent men, there's that one. We know that the death has been the lot of men whose convictions were unconstitutionally secured in the view of later or retroactively applied holdings of this court. Yep. The punishment itself may have been unconstitutionally inflicted, yet the finality of death precludes relief. I know it's so messed up. I can't actually even. I'm just gonna keep reading. An executed person has indeed lost the right to have rights. As one 19th century proponent of punishing criminals by death declared, quote, when a man is hung, there's an end of our relations with him. His execution is a way of saying, you are not fit for this world. Take your chance elsewhere. Yikes. Whew. Thus, a divided court decided that the basic principle that punishment must fit the crime remains a bedrock of Eighth Amendment jurisprudence. And it is for this reason that the aforementioned arbitrariness in its imposition goes beyond the issue of whether arbitrariness is but a mask for prejudice. Arbitrariness necessarily means that humans are being discarded at random. No death penalty scheme may permit people to be killed for the same reasons it would spare another. All right, the prosecutor's discretion in selecting candidates for death. The prohibition on arbitrariness extends to the discretion of the prosecutor. Justice White wrote that the discretion of the prosecutor in deciding the death penalty is broad, or deciding to pursue the death penalty is broad. However, he defined the permissible factors as the strength of their case and the likelihood that a jury would impose the death penalty if it convicts, defendants will escape the death penalty through prosecutorial charging decisions only because the offense is not sufficiently serious or because the proof is insufficiently strong. In other words, the prosecutor must make the objective decision that the case merits punishment and for no other reason. However, then the court held that a prosecutor's decision not to seek the death penalty in like circumstances due to mercy could not be used to show a constitutional violation. The Supreme Court left the discretion of prosecutors to seek death undisturbed, though it provided no real assurance that prosecutors would not use this discretion in an arbitrary fashion. It is axiomatic that the court and the people of our nation rely on safeguards to make our jury trial system as fair as possible. The safeguard intended to protect against the vast discretion of prosecutors is the grand jury. As the prosecution has admitted on several occasions in this case, the grand jury played no part in the decision for death in this matter, and there's a footnote. All right, and then this makes sense the way this is laid out. This is leading up to this part here, right? The grand jury as a check on the prosecutor's death decision. Since 1962, the Eighth Amendment to the United States Constitution has barred states from imposing cruel and unusual punishment where the state failed to follow procedure. This is because the punishment of death has not truly been earned. This is because when the punishment of death has not truly been earned, it is cruel. Thus, the United States Supreme Court held death in its finality differs more from life imprisonment than a 100-year prison term differs from one of only a year or two. Because of that qualitative difference, there's a corresponding difference in the need for reliability in the determination that death is appropriate punishment of a specific case. Oh, here's a North Carolina case. Since 1972, states have been required to find ways to ensure that the death penalty is being imposed in a manner that is not freakish or wanton. The vast majority of decisions followed that. So there might be a typo in here. Hold on. Yeah, I don't know what this is supposed to say. The vast majority of decisions, I think these words are swapped. I think it's supposed to say that followed. So I'm going to switch it. The vast majority of decisions that followed have been concerned with the process by which a defendant is chosen for death, has focused on sentencing. And there's a whole lot of case law cited here. Wow. These opinions essentially hold that, quote, to pass constitutional muster, a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder, end quote. However, ensuring fairness and due process in death cases requires going beyond the sentencing to the safeguards of the proceedings. Prior to Furman, the Supreme Court had held that the 14th Amendment required additional process in capital cases. The court also held that a defendant accused of a capital crime is constitutionally entitled to a lesser included instruction. Okay. Accepting that the Eighth Amendment requires additional process for the selection of defendants to be placed in the pool of possible candidates for death. Let me read that again. Accepting that the Eighth Amendment requires additional process for the selection, I think it's supposed to say selected, another typo, defendants to be placed in the pool of possible candidates for death prior to sentencing, it is clear that the grand jury process as a check on prosecutorial discretion is required. As argued above, it is widely acknowledged that requiring that a prosecutor's charging decision be vetted by a neutral fact finder, and that's the grand jury, right? This is what they're saying, the neutral fact finder, serves as protection against unfounded threats that may be used to coerce a plea to a lesser charge, inflict trauma upon the unjustly accused, the coercive quality of threatening defendants with massive, though unwarranted penalties, and the waste of community resource. Thus, it must be that in death penalty cases, a neutral fact finder must find probable cause exists to believe that the aggravators alleged by the state exist and outweigh the mitigating factors in order to ensure that death may be sought in order to comply with the Eighth Amendment. Without this check, we have the arbitrariness of the current system, where prosecutors are the driving force behind where death is sought. Without this check, the freakish and wanton nature of the death penalty cannot be resolved. Without this check, the nation continues to fail to live up to the promises explicitly listed in the Constitution to protect its citizens from the death penalty. So, conclusion, they're saying, get rid of it, basically, right? And there he is, Jay Logsdon. as we figured. Okay, so done with that one. Up next, we have motion to strike the death penalty on grounds of contemporary standards of decency and memorandum in support of motion. So this one's 130 pages long, but I remember kind of scrolling through it. I think a lot of it is like exhibits and stuff. So we'll see what we can do. Okay. More Americans, there shouldn't be an apostrophe here, believe the death penalty is applied unfairly than fairly. And here's a link. Summary of argument. Idaho's legislative and judicial construction and application, let me zoom in a little bit. Okay. An application of capital punishment violates the prohibition against cruel and unusual punishment contained within Article 1, Section 6 of the Idaho Constitution and the 8th and 14th Amendments to the United States Constitution. Punishment which does not comport with the evolving standards of a modern civilized society is cruel and unusual. In recent years, a national consensus in opposition to the death penalty has begun to emerge. The lack of an active death penalty in the majority of states within the United States indicates that there's been an ideological shift and that the punishment now violates our contemporary standards of decency. The vast majority of modern civilized societies already abolished capital punishment because the execution of human beings by governments is recognized to be a violation of the dignity and spirit of human beings. The institutional killing of civilian prisoners affronts the modern civilized world. The United States has been routinely condemned by the international community for continuing to execute its own people. The United Nations Commission on Human Rights and most organized religions have called for a moratorium on executions with a view to completely abolishing the death penalty. Since Idaho continues to actively pursue and impose death as a sentence for criminal law violations, Idaho does not comport with the evolving standards of contemporary society. By way of example, Idaho recently halted its first lethal injection execution in 12 years when the corrections team was unable to. Oh God, that was horrifying. I remember that. God, if you don't know about it, don't read it. It's just so messed up. It's beyond. As the evolving standards of modern society reflect abhorrence to capital punishment, Idaho's continuing effort to execute its own citizens, including Mr. Kohberger, is not in comport with the evolving standards of a civilized modern society. Rather, the state's efforts to have Mr. Kohberger executed violate his right to be free from cruel and unusual punishment, as that right is guaranteed by the 8th and 14th Amendments, and etc. Argument. Punishment is cruel and unusual if it is inflicted in an uncivilized and inhumane way. A claim that punishment is excessive is judged not by the standards that prevailed in 1685, when Lord Jeffreys presided over the bloody assizes, or when the Bill of Rights was adopted, but rather by those that currently prevail. So I wonder what this is. Was this like a sword fight or what? I don't know. Curious. I want to know more about Lord Jeffreys. Should we do a deep dive into Lord Jeffreys at some point? I feel like we're going to have to. Oh boy. I'm going to table that for now. The Supreme Court has established a two-step process to evaluate a claim that a form of punishment violates contemporary standards of decency. All I could think about is Lord Jeffreys. Blah, blah, blah. Here we go. Let's take a look. Unusual application. Okay. In the vast majority of the United States, a death penalty sentence or executions are rare events, and they are becoming increasingly rarer each year. Yep. We know this. There's less of them. I mean, this is kind of all standard stuff. I know more about Lord Jeffreys. In the past 10 years, 5 state legislatures have abolished the death penalty: Virginia, Colorado, New Hampshire, Maryland, and Washington. I'm going to zoom out so I can see what else is coming up on here. Public opinion. Again, that was kind of already mentioned. International community. Yeah, I know. We're the laughingstock of the planet for myriad reasons. By we, I mean the U.S. Human rights. Okay. Religious organizations. I don't know if there's really much in here else to read. I think that this is all things that are probably kind of common knowledge as to how the rest of the world views the death penalty. Yeah, I mean, And here's the exhibits. Okay, so yeah. Okay, yeah, I'm not gonna read it. Yeah, that's what I thought. Okay, so that's pretty much it. So meanwhile, where Lord Jeffries go? Just to make sure I look him up at some point. Lord Jeffries. Where did he go? Where did he go? Where did he go? Do 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 do. Where did it go? Do, 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 do. Where the heck did he go, Lord Jeffries? It's like once I'm looking for it, then I can't find it, of course. Naturally. Where did he go? Okay, well. Okay, yes, there it is. Okay. I wanted to make sure I had the year 1685, Lord Jeffries. So we'll look that up at some point. All right. Next, moving right along, we've got striking the death penalty on grounds of vagueness in balancing aggravators and mitigators. All right. Only 143 pages on this one. Okay, issues. Constitutional limits on manner of execution. History of executions in Idaho. Lethal injection in Idaho is not viable. The firing squad is not and never was constitutional. All righty. Proceeding with capital murder charges in this case is unconstitutional because executing Mr. Kohberger by means of lethal injection or a gunshot, as conceived by the Idaho Department of Corrections, would violate his rights to be free from cruel and unusual punishment under the 8th Amendment. I mean, I agree. I mean, I forgot about the cruel and unusual punishment thing. There's like so many ways to argue that this is a terrible idea that you can easily forget that one when that's obviously like one of the main ones, right? Forgot about that one, the 8th Amendment. It would also violate his rights under Article 1, Section 6 and 13 of the Idaho Constitution. An execution procedure that involves, quote, the unnecessary and wanton infliction of pain, end quote, violates the 8th Amendment. The 8th Amendment's prohibition is not static, but it is responsive to evolving standards of decency and contemporary values. And that's actually what we just saw referenced in the last document. So yeah, execution by lethal injection constitutes cruel and unusual punishment. Furthermore, the 14th Amendment guarantees that no person may be deprived of life, liberty, or property without due process of law. A violation of procedural due process requires a showing of 1, constitutionally protected interest in life, liberty, or property, 2, governmental deprivation of that right, and 3, constitutional inadequacy of challenge procedures affecting the deprivation. A prisoner sentenced to death has a constitutionally protected interest in life that is not extinguished by the conviction and death sentence. So in other words, just because you execute them doesn't mean that their right to live goes away, basically. The manner of execution is set by the legislature in Idaho. And this statute here was amended just last year. The new version of the statute is. All right. So let's take a look. This is interesting, right? Because Idaho's, they're doing it. They're killing people, whatnot, right? And we know they've been having some issues. So what's their statute say? It was just updated last year. 1, the punishment of death shall be inflicted by continuous the following methods. A, continuous intravenous administration of a lethal quantity of a substance or substances approved by the director of the Idaho Department of Correction until death is pronounced by a coroner or a deputy coroner, or B, firing squad. 2, not later than 5 days after the issuance of a death warrant, the director of the Idaho Department of Correction must determine and certify by affidavit to the court that issued the death warrant whether the execution by lethal injection as described in subsection 1A of this section is available. 3, if the director certifies that lethal injection is available, the method of execution shall be lethal injection. If 4, if the director does not certify that lethal injection is available, fails to file a certification as required pursuant to subsection 2 of this section, or otherwise determines that lethal injection is unavailable, the method of execution shall be firing squad. 5, if the court holds that lethal injection is unconstitutional on its face or applied, or otherwise determines that firing squad is a constitutionally required method of execution, the method of execution shall be firing squad. 6, the director of Idaho Department of Correction shall determine the procedures to be used in any execution. 7, the provisions of this section shall apply to all executions carried out on and after the effective date of this enactment, irrespective of the date sentence was imposed. Why was I thinking that they got to choose the person who's being killed? Am I thinking of a different state? Why did I think that they got to choose? Because that would have had to have been in that statute that we just read. So, okay. Maybe they used to have that option and then they deleted that when they updated it last year. I don't know. The Idaho Supreme Court has ruled that the word any is what is now subsection 6 refers to each and every person to be executed as an individual rather than a broad policy for all defendants. The court held that because of the legal issues with the manner of execution, the director of the Idaho Department of Corrections must provide each individual to be executed with the procedures that will be used in their case in advance of the execution so they may be reviewed and challenged. Thus, one condemned to die in Idaho has no real way to know how they will be killed, at least until the death warrant is issued. And at that point, they have 5 days, right? Still, as things stand, Idaho has no viable method for killing Mr. Kohberger. Okay. This is depressing. Up until 1978, in Idaho, death was imposed by hanging. Oh my God, I don't even know if I can read this. The actual structure of hanging was changed more than once because the difficulty of getting necks to snap as desired, leading to a lack of immediacy in the execution. The last man hanged by the people of Idaho was Raymond Snowden on October 18th, 1957. So they had a trap door. Oh, it was just awful. They're just describing this execution of the last time somebody was hung. It's just awful. I don't know that I can read all this. It's just hard. Okay, precisely why Idaho gave up on hanging has no simple explanation. Perhaps the guards telling stories of the sounds of the trapdoor being tested repeatedly in the presence of the doomed What? There's another typo in here. I think there's not supposed to be a dash here. Okay, let me read the sentence again and try to fix this typo. Precisely why Idaho gave up on hanging has no simple explanation. Perhaps the guards telling stories of the sounds of the trapdoor being tested repeatedly in the presence of the doomed man made people feel uncomfortable with the whole ordeal. Maybe it was the idea of strapping a man onto a board and wheeling him off to kill him with a bag over his face. Whatever it was, the how was relatively simple. In 1978, as Idaho's legislature tried to devise ways to kill people that would satisfy the demands of the United States Supreme Court, these senators joined forces to amend the law to require lethal injection. Okay, let me just see what else we can have here. Okay, so here we go. During that legislative session, the Department of Corrections and the Idaho Medical Association tried to reach a compromise so that the killing could happen. This is when they started having troubles getting the ingredients for the injection, right? The firing squad was included essentially as a backup, and one drafter of the bill thought was likely unlawful. This was the original birth of the firing squad. In 1982, Idaho statute permitted the director to use the firing squad whenever the lethal injection was impractical. The only directive provided for the firing squad was the director would decide its members. The original firing squad, however, never got off a shot. In 2009, the firing squad was repealed with a statement of purpose that read, yeah, basically, no, we're not doing it, essentially, right? This reasoning was taken from the statements of the Deputy Attorney General Bill Von Tagen and Senior Deputy Attorney General, blah, blah. This brings us up to this year when Lamont Anderson, now lead Deputy Attorney General for the Capital Litigation Unit, returned to the legislature to ask for the firing squad back. The majority in Glossop never referred to the firing squad as quick and painless, except when it, okay, so this is where they're getting, remember, to the cruel and unusual punishment, right? Because there could be this idea that some could say, right, that perhaps, I don't know, I don't want to know any on the details of what type of bullet or gun, right? But the idea, if it's quick and painless, right, that's because they're trying to avoid the cruel and unusual punishment, right? So that's, I think, what they're getting to here is that no one ever said the firing squad was quick and painless. So it seems clear from the opinion that the majority was simply pointing out that the dissent's view that all methods for execution prior to lethal injection become unconstitutional, and was a distinction without a difference from the view that it was time to simply stop killing people. Okay. Idaho does not have the ability to kill a man with an injection at this point in time and likely will not in the future. This is because of three things. One, a lack of trained medical personnel willing to take life. Two, the difficulty in finding drugs that kill without creating unnecessary pain. And three, the difficulty in purchasing those drugs that have been held to be appropriate for killing a person by the courts. The most recent document detailing how the director would kill a man is Idaho Department of Correction, blah, blah, blah. This court should review the procedures adopted in 2021 that the Idaho Department of Corrections could not implement. Okay, yeah, I'm not going to read the ingredients. No. Yeah, I'm not going to read all. It's beyond what I can handle because it's too depressing. These horrible substances and all that. I mean, I think most of us know that it's wrought with error, right? Or fraught with error. I can't remember. My brain is losing it because of this type of stuff. So it's let's just say this, it's raw and fraught. It's both. Okay. Firing squad. When considering whether the firing squad in its rebirthed iteration is cruel and unusual punishment in violation of the Constitution, both the United States and Idaho, it helps to have an idea of what it will look like. No, I don't want an idea what it's going to look like. So in 2010, somebody volunteered. Oh my God. I can't read it. Guys, I can't read it. Well, that answers my question about what type of gun. It's a 30 caliber Winchester rifle. Unfortunately, the only thing I know about firearms I learned from Murdoch, a little bit from Rust, but mostly from Murdoch. So, and there were no Winchester rifles involved. So honestly, I have no reference for what that even is. If it's not a 300 blackout or a shotgun, okay, so I'm just not reading that. I'm just not doing it. Eerie similarity of the killings. It's just, I can't, dude. It's too much for me. Okay, the Court of Common Pleas also found the firing squad to be cruel. Here it is clear that the firing squad causes death by damaging the inmate's chest, including the heart and surrounding bone and tissue. This is extremely painful unless the inmate is unconscious, which, according to these doctors, is unlikely. Rather, the inmate is likely to be conscious for a minimum of 10 seconds after impact. Can't. Wouldn't you? Okay, well, the questions I don't even want to ask. Like, wouldn't you do better? I don't know. I don't want to, I'm just thinking like a gunshot to the head. Wouldn't that be maybe? I don't know. I don't know. Okay. Oh my God, it's just awful. The Supreme Court of South Carolina has now found that the firing squad is neither cruel nor unusual. It does so by separating the horrors of what it is contemplating from what it calls the critical question, or as they put it, interesting. Our definition of cruel does not call upon us to analyze what the death chamber looks like after the execution has been carried out. There is no consideration in our analysis of whether a method of execution is cruel of the dramatic imagery set forth in the Chief Justice's dissent, the circuit court's order, or the inmate's brief, such as blood soaked on the inmate's clothing, spatter on the walls. Oh my God, I'm not. Physical pain, blah, blah. While each of these might have been political concerns addressed by our General Assembly, they are not constitutional concerns. Our definition of cruel defines the critical question and requires us to focus on the risk of unnecessary and excessive conscious pain. Having thus turned death into a sort of parlor game, guess at how much pain one might experience after being shot in the heart, right? So they're shooting him in the heart and not the head. This is messed up. Okay, having thus turned death into a sort of parlor game, guess at how much pain one might, the game being, right? Guess at how much pain one might experience after being shot in the heart. The court finds it is not convinced it sounds all that bad and thus cannot qualify as cruel. The only authority it relies upon are the various statements of liberal justices and judges dissenting in various cases. Given that any person chosen at random from the street could probably name a few pleasanter ways to die than being tagged up, bagged, and shot, it's hard to see this opinion as anything more than a political stunt. In any case, the court's eventual decision to decide it is not unusual, despite the fact that almost no one uses the firing squad except when chosen by the condemned. Okay, so I guess you can choose it. That's what I was saying earlier. To uphold its use in South Carolina, where the law only permits if, okay, that's why. Okay, so in South Carolina, they can choose it. The condemned can choose the firing squad, it looks like. But that makes it the opinion of no use to the state of Idaho. Idaho's statute authorizing the firing squad as punishment is excessive because death by firing squad subjects the human being killed to unnecessary physical pain. Even in the best circumstances, meaning accurate shots fired and hitting the intended target area, death is not immediate. Awareness and pain continues and pain exists. Conclusion. Based on the foregoing an argument, so they're going to argue about this. I wonder what all these exhibits are. I'm still wondering, I mean, again, it's something I don't really want to like look up or whatever, but I don't know why they don't just shoot them in the head, because wouldn't that be better? Like not better. It's in terms of, they're shooting them in the heart. And so then there's the issue of, okay, yeah, these are just minutes from the meeting, the judiciary meetings. And they're saying that they can still be alive for a period of time. Anyway, okay, moving right along. Cheery subject. All right, so now we're gonna motion to strike it on grounds of arbitrariness. We've heard a bit about the arbitrariness. It's been referenced in the other motions here. But now we have a whole document dedicated just to the arbitrariness. Okay. Some of this was in the other one that we read on the last live stream, because I remember this wording. The utter disregard part. Yep. Okay, because remember, some of these had the same sort of like introductory section was like the same. All right, argument. Here we go. Arbitrariness in the selection and imposition of the death penalty is cruel and unusual. So again, going with the Eighth Amendment here, right? Cruel and unusual punishment. They're saying because it's arbitrary, it's cruel and unusual. So in other words, so far we've heard like it's cruel in terms of the cruel and unusual part, right? We've heard, well, what just to summarize what we've heard so far or read so far tonight. We've read that the first issues were that the prosecutor alone has the power to just decide who's going to have the death penalty, when really it should be left up to a neutral fact finder, such as the grand jury. That was like the first thing, right? And then it was I think that it went from there to just different, the cruel and unusual, right? So the Eighth Amendment, cruel and unusual, what constitutes cruel and unusual. And then from there, it went to like the killing methods, right? And then now we're into the arbitrariness in relation to being cruel and unusual. All right. So arbitrariness in the selection and imposition of the death penalty is cruel and unusual. Idaho's death penalty scheme fails to narrow in a constitutionally adequate way the class of persons eligible for the death penalty and creates a substantial and constitutionally unacceptable likelihood that the death penalty will be imposed arbitrarily and capriciously. And again, some of this echoes what we've already read in other documents. And there's the Eighth Amendment referenced again, as per usual. What I'm wondering if there's going to be like anything different in here, or if this is just sort of rearranging other things that were already cited. Idaho's capital punishment laws fail to narrow the types of murder. And I think that was already referenced in another motion. In fact, I'm sure it was. Okay, there are 11 statutory aggravators outlined in this Idaho statute here. These statutory aggravators cover virtually all types of murder, right? And that was actually in one of the first documents we were reading, where they were saying basically every murder could qualify, right, as a death penalty case, technically, because it just needs that one statutory aggravator, and they're all going to have one. So that's why that's part of the arbitrariness, right? That the prosecutor just gets to kind of decide, because technically they all could be, right? All right, so these statutory aggravators cover virtually all types of murder and include any murder in which the defendant committed a risk of death to many people, any murder for remuneration, any murder that's heinous, atrocious, cruel, manifesting exceptional depravity, any murder in which the defendant exhibited utter disregard for human life, which really one could say is any murder, right? Any murder that was committed in the perpetration of or attempt to perpetrate arson, rape, robbery, burglary, kidnapping, or mayhem, and the defendant killed, intended killing, or acted with reckless indifference to human life, and any murder in which the defendant exhibited a propensity to commit murder and will probably constitute a continuing threat to society. That one's what it makes no sense, because it's like, what? Has nothing to do with it has nothing to do with the crime. Anyway, okay. I think we talked about that on the last live stream. Under Idaho's death penalty scheme, there are so many aggravating circumstances so broadly construed that the aggravators accomplish no narrowing. Yeah, right? Idaho's death penalty scheme defines death eligibility so broadly that it creates a greater risk of arbitrary death sentences. Okay, and then here's the study. They've referenced the study before. The main problem with the expansion of death eligibility is that the statutory list of, quote, aggravating circumstances, unquote, is the one and only place in the entire death penalty system where substantive limits can be imposed on the death penalty that are not discretionary. If the statutory list is overly broad, then the discretionary decisions of prosecutors, judges, and juries must carry the entire burden of ensuring that the death penalty is applied narrowly and reasonably consistently. If the statutory list includes virtually all first-degree murders, then discretionary decision makers must carry the entire burden of selecting from such a large pool a small handful of the worst murders for which the death penalty will be imposed. Moreover, discretionary decision makers often do not even get to see all the cases in the pool. Juries, for example, see only one case and thus cannot easily compare that case to other death-eligible crimes. As a result, Idaho's scheme is possibly worse than what the Supreme Court struck down in Furman. Recall that any death penalty scheme under which fewer than 15 to 20% of statutorily death-eligible defendants are sentenced to death permits too great a risk of arbitrariness to satisfy the Eighth Amendment, and compared to what Professor Cover found. So, the expansion of death eligibility also contributes directly to the serious and well-documented problem of racial disparity in the application of the death penalty. When various decision makers within the criminal justice system, and especially the jury, possess too much discretion over capital sentencing within a large pool of death-eligible murders, then overt and hidden prejudices can influence decision. By narrowly restricting categories of death eligibility to a small number of precisely defined and extremely heinous murders, and thereby restricting the discretion of capital case decision makers, the problem of racial disparity can be addressed in the most meaningfully possible way. Additionally, the Idaho Supreme Court held that Idaho statute permits non-statutory aggravating evidence, right? And that we talked a lot about in the last live stream. That's basically the victim family's testimony, right? Now that a jury is free to hear any bad evidence that state can muster, and by that they mean things that would not be admissible in trial. Again, we discussed that at length, and we learned a lot about how that goes. There's no real way to know whether juries will ever base their decision for death upon the statutory aggravators the legislator passed to comply with. Right. So they're saying that you never actually learn, what really influenced their decision? Was it because of the statutory aggravators, or was it because they were persuaded by the people crying, right? Basically. And now we're back to the geography. Interesting. Idaho's cap. This geography, really crazy. But that kind of makes sense, right? Because the way the prosecutor's office works, right, is done by the counties. Okay, let's see what else we got in here. Conclusion, yeah, get rid of it. And there's some more stuff. And again, all these exhibits that are being attached are they're gonna present in the hearing. Okay, so we don't know when that hearing is. It's gonna be before the new judge. That's all we do know. But when we have that hearing, then they are gonna have experts, different experts than the ones we've already seen. Different experts come in and they're gonna present all this information that I'm not reading, because kind of what happened last time, right, with the hearing, with the motion to change venue, was like I read the entire, like almost the entire 300 and something page document, right, with the exhibits, and we went over all of it. But then it's exactly what the experts presented at the hearing. So I mean, I guess it makes sense to do one or the other, and I suppose in this case, I would rather watch them present it in the hearing, and not read it, you know, just to not be redundant. So, and this is the last document, guys. So we are almost. So this is the one, penalty on grounds of international law. So this is the one that's the, I don't know, international treaties. I guess is probably the least substantial in my opinion. But this has to do with like the international standards against torture and stuff like that, essentially. International Covenant on Civil and Political Rights. It's 481 pages. Wow. So yeah, again, this stuff is going to be better presented by an expert in the hearing. I'm not going to read all this. But yeah, I mean, yeah. This is all very, what's the right word? I don't know what the right word is. It's all very dense and scholarly, and, you know, anyway, it's 481 pages. But yes, we will hear from the expert for that. So, so let me pull up. This. Coolio. So I didn't expect to get through those as quickly as I did, but yeah, so, but we did it. We did it, guys. We got through all of them. So quick little update on the plan for the other things going forward. So today being Thursday, tomorrow we will have the next Ezra live stream. And so tomorrow being Friday. So that will be, I think it's episode 16. And then I'm thinking I'm going to have episode 17 on Sunday. Basically, my goal is to have it finished before Donna Adelson's trial starts, which I believe the jury selection starts like on Monday, I think, but like opening statements are for Friday, as in a week from tomorrow, I believe. So I think we'll be able to do it. I think we'll be able to have it finished by then, just because I know that a lot of people are going to be wanting to watch that. And so, but I think we would be on track for that anyway, because we're getting close to the end. So yeah, so as always, though, I will continue to keep up with any new documents that are filed here for this case. But yeah, so be on the lookout for, again, anything else that comes out here, and then Friday and Sunday for Ezra. And that should do it. So thanks, guys, for watching. Thanks for being a squirrel. And I'll see you guys on the next one.